A summary of everything that is described in this video can be found on CoinMarketCap. Additionally, if you would like to get additional information regarding XRP and other cryptocurrencies, please make sure to keep clicking the subscribe button. First, have a look at this. An update on the XRP v CCC lawsuit, which is said to have been breached by Ripple, is disclosed by attorneys, along with the date of the update. In its response to the SEC remedies-related brief, Ripple has come to the conclusion that the court should not grant the SEC's request for an injunction that would be in conflict with the prejudgment interest. This is due to the fact that the SEC has not provided any evidence that any misconduct or carelessness occurred. Ripple asserts that the court ought to impose a civil penalty that is equivalent to little more than $10 million. In addition, the cryptocurrency company submitted a request to strike a new expert witness that the Securities and Exchange Commission (SEC) had included in its short concerning remedies. The company claimed that the SEC had broken both the procedures of the court as well as the laws that were included in the SEC remedies short. Ripple has filed a motion to overturn the verdict that Fox has rendered. Ripple has reportedly submitted a motion to strike additional expert papers that the SEC utilized to strengthen its brief and final conclusion about remedies. Sources have stated that this request has been submitted. After the deadline for establishing remedies had passed, the Securities and Exchange Commission appended a declaration and two supporting exhibits that were written by expert witness Andrea Fox. These materials were presented to Magistrate Judge Sarah Knepper. Ripple, the Securities and Exchange Commission, asserts that Schul engaged in sandbagging in order to justify her late submission and her failure to disclose pertinent material, which ultimately led to the creation of what is known as the Fox Declaration. SEC officials did not make the Fox disclosure available to the general public until March 22nd. Following the completion of the process of finding potential solutions 1 month later, in addition to being an accounting study, the Fox Declaration also serves as a summary witness, which involves providing a major judgment regarding remedies. As far as the Securities and Exchange Commission is concerned, Fox did not qualify as either an expert or a fact witness. As a consequence of this, the Commission asserts that Fox has failed to meet the deadline for providing papers to the court. If the litigation were to be restarted, it would also result in a delay, which would make Ripple less confident about the motion and the deadlines that the attorneys have set for themselves. To Morgan, one of the attorneys working for XRP stated that Ripple makes perfect sense, and that discouragement should not be allowed in situations when it would be beneficial to investors. Additionally, he elaborated on the relevance of the move to strike the Fox Declaration, which was utilized by the SEC to assert that certain institutional buyers had experienced financial injury. He stated that the motion was employed to strike the Fox Declaration. As noted by attorney James Murphy, Ripple has the ability to triumph in the event that the remedy short judgment is granted. In order to ensure that there is no discouragement, he is of the opinion that Ripple has the potential to earn the support of Judge Torres in order to apply the AIM case. According to statements made by Matt Kalaman, the Securities and Exchange Commission (SEC) is expecting to receive one final brief on the damages questions on May 6th. He also claimed that the decision would be reached within 60 to 90 days based on the judge's assessment following the final brief. This is a significantly faster time frame than the choices that were made regarding the summary judgment. In accordance with the assertions of attorney Jeremy Hogan, the remedies case is anticipated to be resolved during the summer, and appeals are anticipated to drag the Ripple v. SEC lawsuit into the next year. Regarding the realm of cryptocurrencies, Ripple Labs and the Securities and Exchange Commission are both parties participating in a matter that is of significant importance. A significant impact has been made on the cryptocurrency industry as a result of the legal procedures that began in the year 2020. In addition to this, they have had an impact on the regulatory environment and been responsible for expanding the parameters for the classification of digital assets. This blog provides a comprehensive analysis of the timeline of the XRP v SEC case, focusing on the most important decisions and the implications that these occurrences had on both parties and the cryptocurrency community as a whole through the utilization of its Ripplite network and the XRP cryptocurrency. The purpose of Ripple Labs, which was established in 2012, is to revolutionize the process of transferring money across international borders. The Securities and Exchange Commission (SEC) filed a lawsuit against Ripple in 2020, following the emergence of allegations regarding the nature of XRP token sales over time. The SEC accused Ripple of violating federal security laws by executing an unregistered securities offering the initial sale at XRP, which the SEC considered to be comparable to the offering of an initial public offering of securities. The lawsuit was filed in response to the allegations that emerged over time. In the course of the enforcement action that was brought by the SEC, this was the primary target. Both the assertions made by the Securities and Exchange Commission and the rebuttal made by Ripple in an effort to differentiate XRP from other cryptocurrencies such as Ethereum and Bitcoin. In response to these allegations, the SEC pension argued that it should be classified as a security. Ripple stated in its answer that XRP was not subject to ID's regulation because it had value as a currency and would be used for a variety of purposes. Ripple also stated that XRP will be used for a variety of purposes. Ripple contested the SEC's assertion that there was insufficient prior notice regarding the classification of XRP. Additionally, Ripple raised concerns about the possibility of prejudice in the application of securities laws that pertain to digital currencies as a result of the incidents that occurred during the legal dispute between Ripple and the SEC. There were a number of significant events that took place, all of which had an impact on the way the legal processes were carried out. On December 21, 2020, the Securities and Exchange Commission will launch a lawsuit against Ripple Labs on the grounds that the company's CEO, Brad Garlinghouse, and co-founder Chris Larsen engaged in an unregistered securities offering worth $13 billion by selling XRP. The case will be filed on the grounds that the company's CEO conducted the offering. The cryptocurrency exchange Coinbase, which is widely recognized as one of the most prominent cryptocurrency exchanges, has stated that it will withdraw XRP from its listing on December 28, 2020. Garlinghouse disclosed that Ripple would continue to prosecute the legal battle despite the fact that the SEC had imposed certain limitations, due to the fact that Ripple Labs Inc. was the target of a lawsuit filed by the Securities and Exchange Commission. Coinbase made the choice to take this action. Coinbase indicated that there was a dispute with Ripple that took place on March 3, 2021, as well as the fact that there was a lack of adequate notification sent out by the SEC. Ripple Labs asserted in a recent court filing that the Securities and Exchange Commission had failed to provide sufficient notice that transactions utilizing XRP were forbidden, or that the SEC would subsequently characterize XRP as an investment contract prior to the filing of the SEC's complaint. Ripple Labs' argument pertains to the fact that the SEC had not provided sufficient notice. According to Ripple, a significant number of market participants had been trading XRP for years under the mistaken belief that it was not any kind of investment contract. In addition, Ripple Labs asserted that XRP is not an investment contract during their presentation. The following is a rebuttal to the reasons that Ripple and its management have presented. A request for a fast hearing has been submitted by the Securities and Exchange Commission on the 8th of March, 2021. In a request that was submitted to the judge on March 22, 2021, the Securities and Exchange Commission requested that a rapid hearing be held in order to address the issue of fair notice, as well as other concerns. It was acknowledged that XRP is valuable both as a form of currency and as a utility instrument. This is due to the fact that XRP possesses value in both of these capacities. After careful consideration, Judge Sarah Nern came to the conclusion that it is separate from other digital currencies such as Bitcoin and Ethereum. As a consequence of this, the similarities and differences between various digital assets were brought to light. On April 13, 2021, Hester Pierce gave a presentation in which she provided her concept for Token Safe Harbor 2. A deadline of June 14, 2021 has been set by the court for the Securities and Exchange Commission to publish its policies governing the trading of cryptocurrencies. The proposition was to provide developers with a grace period of 3 years, during which they would be immune from the restrictions that govern securities investments. The intention behind this grace period was to provide developers with the opportunity to get a more in-depth comprehension of the role that they play inside decentralized networks.